Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everyone? Good morning. So, Karen Reed's having a hearing today. It's going to be about the ARCA stuff. Oh no, we just had a fan 2 seconds ago. But that's what this looks like now. Hey, Susan Hicks. Hey, Shelly F. Hey, Taterbug. Oh, we're back to the fan. The Commonwealth is trying to remove the ARCA experts because they haven't gotten all the discovery, and Karen Reed is not handing it over.
That's right. The HVAC system in that building is built, and we spent a lot of time close.
Thank you, Marcy Denton. They're going to also do the motion to dismiss today? Or is this just about the ARCA? I didn't even know they handed over their motion to dismiss. Hey, Twisted Tragedies, nice to see you. Hey, all, and Roberta, I'd like to thank you all for your support of Lindsay. She needs us all rallying together. Okay. To help. Lindsay still needs a lawyer. Let me put up her Give, Send, Go. And if you have, everyone has $5, even at their brokest. Lindsay really needs it. And she also feels really, I would think, really alone, as this is the object of these smear campaigns. So have a heart and send her some dough her way. I'm sorry, guys. It is so cold here in New York. I know I can even hear. I have a little heater on in my my room here. I can hear it through the headphones. It's like yesterday it was the winds. Now it's my heater. I just can't turn it off. I'm too cold. I'm too cold.
Cell phone is in the mute, please.
Also want to thank everyone who donated to it. There's a update from Lindsay from the 21st of message from Lindsay to everybody on the website who's donated. Hey Angela. Hey Jennifer Ray. Thanks for donating to Lindsay. Appreciate it. Hey Tammy. Thank you, Tammy, for donating to Lindsay. Leaving her that nice message or messages.
All persons have any business before the Honorable Beverly Cannoli, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right, I was told counsel wanted to see me at sidebar.
Briefly, Judge.
We're going to need a bigger table for all these defense attorneys. It's ridiculous. Elizabeth Little is back. Right. Are we going to have to listen to Alessi and his boring, long, self-indulgent motions? I hope not. I loathe him. I feel the same way, Jennifer Ray. Oh, damn, Alessi's there. Him and Little go get coffee for Jackson, right? It just feels like Jackson and Yannetti are sitting back doing nothing. And Alessi's doing all the work. That's what it feels like. So bored. He's like the nerdy kid trying to get in with the cool kids.
All right, so what I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at Mass Court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
Good morning again, Your Honor.
Good morning.
I spoke to Mr. Albano last week and again last night.
Okay.
And on behalf of Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to receive all of the information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the date you
They'll
said?
have it on or before March 1st.
Okay. All right, so that motion is allowed by agreement and the order is right here, Mr. Clerk. All right. Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right. So paper number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage in law enforcement custody. And the opposition, Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number?
I do, just a second.
Okay.
I'm sorry, the opposition too.
Defendant's motion to compel production of a forensically sound copy. We'll get started in the argument and you can give me that.
506,
Great, thank you.
that's the response.
Right. Okay. Who's arguing this motion for the defendant?
I am, Your Honor.
Okay.
Thank you, Your Honor. My comments will be relatively brief. We filed this motion basically because we had no choice. We were following the court's instructions, meeting with Mr. Brennan after court the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present. If all the information was a download from some iCloud account, unnamed iCloud account, as long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We're predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired officer's or a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that, in fact, it did have some video footage on this either iCloud or video system. We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that, because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
Mr. Brennan.
It seems like another effort to portray some type of injustice wrought upon the defense, that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer have the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after, because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process. And I wanted to ask firsthand anybody that was there about the process, because I wanted to do due diligence. And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. He never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. And what he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time. He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it. And so I thought, well, there's more information that exists. It's not going to be a 24-hour period. It's probably going to be cumulative, but I wouldn't know unless I looked. Now, the standard practice is the Commonwealth would then just ask the detective to download a copy, and we'd meet our Rule 14 obligations by providing it to the defense. It's as simple as that. The defense is entitled to know more. There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive. But I called the defense, not only due diligence, professional courtesy, to say, you are already involved in the process with the NVR DVR. I've already invited you to bring an expert. I want to download this information that he copied over time and give you a copy. And they said, we don't know how we feel about that. Can you wait? I did not want to wait. I don't want any video being overwritten or destroyed. It was against my judgment, but I was deferring to the defense request to wait. And now it has become part of the spirit of their argument of oppression that somehow there's something odd or miraculously hidden about this. It is simply video that the sergeant clicked and dragged to another file that we can go in, click and drag it to a hard drive, and give them a copy. After you asked us to speak in the back room, the 6 of us were there. We had a conversation. We said we would simply copy the video, and then as another measure, which was unnecessary, we'd actually videotape it. Now, we did that because the defense wanted us to, and also it seems if it's on videotape, it can limit baseless allegations later. So we were happy to do it. And then when we got back to the office, the request changed under the spirit of Brady violations and due process. It was suggested that we were supposed to engage now in a different process, and that was metadata. I don't even know if the detective file has metadata. I don't actually know exactly what they're looking for. It is a simple click and drag process. Whatever video exists with the sergeant, we will give them. We're obligated to give them. The only delay has been because they've asked for all these different accommodations and different styles of doing it. And so we want to meet our responsibility, download the videos, and simply give them to the defense. There's nothing else about this issue. It's that simple. And technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process. So we'd like to finish our Rule 14, download the video, give it to the defense, and then they can make any commentary or argument they want about it.
How quickly can you do that?
I imagine we could do it one day, but today it'll get done by the end of the week.
You want to maybe, I'll be heard briefly.
Yes.
Very, very briefly.
Take your time.
Thank you. Mr. Brennan's confidence notwithstanding, I don't know what to say about that, pretty immaterial, what his level of confidence is. I'm more concerned about his obligations as the representative of the Commonwealth. And he really didn't talk about the metadata in his argument. He didn't talk about the metadata in his written presentation, his opposition, because he knows that we're entitled to it. That's all we're asking. One thing I really agree with him on, this is simple. This shouldn't be a fight. He's got video data. He's got metadata associated with that video data, and there's probably, maybe, log files. If there are, we're entitled to them, and he should want to give those over to us. He just indicated that this detective file, whatever it is a hard drive. Every electronic storage device has metadata on it. So even if it's a drag and drop, makes it sound super simple, that electronic drag and drop will have metadata associated with it. That hard drive, every time it's accessed and the data on it is accessed, also will have metadata. Euphemistically, it's called electronic fingerprints. Every single, whether it's a thumb drive, a hard drive, or a server, every one of them have metadata on it. So it's not difficult. And we're interested in the videos, but we're also interested in the data that is behind the videos as well. And I wouldn't be nearly so concerned. And Mr. Brennan makes this argument, well, the defense is just up here, again, pontificating about how they've been oppressed, I think is his word. Nobody's talking about oppression. We're talking about fairness. We have been told from day one, before the first trial ever started, Your Honor, this court recalls this. We don't have any further video evidence. Whatever videos we have, we've given them over to you. Then on April 4th, in the shadow of the trial starting, we get more video. Where did that come from? Then in the middle of trial, we get more video. Happens to be an inverted video. Where did that one come from? Then on October 24th, we get more video. This past October 24th, well after the trial, we get more video of Brian Higgins out at the location of CPD on his phone. Where are these dribs and drabs of video coming from? That's all we're asking. And Mr. Brennan should want the
October 24th. Did that video come with the metadata?
No, it's just video. It's a video file. And I'll also, that's a great point, Judge. When you have a hard drive that's storing video files, my understanding, again, I'm no expert. My understanding is that hard drive will likely have some sort of an EXE program, an executable program on it to play the video or to store the video. It'll also have potentially some sort of video player, maybe a proprietary player on it, and then there's going to be the file. So that's what we're asking for. This is the metadata associated with all those things. It's not a hard ask, it's not a heavy lift. There's no reason to justify, well, you know what, I'm just going to drag and drop this and you get the video and nothing associated with the video. That's all we're asking.
Any further response, Mr. Brennan?
Your Honor, there's no attempt to deprive the defendant of anything. In fact, historically, if we look back, we invited them to come to the actual hard drive and do it themselves, and they declined. So this isn't an issue where the government is trying to hide something or keep something from them. If there was obvious metadata, we would provide it, but I don't understand this is that type of system. So they're asking for certain things that I don't think we can accommodate. If they want to come, they're invited. If the court wants me to inquire of a retired sergeant detective about metadata, I'll do that. But the issue is going to become that when we drag and click these videos, and if there is no metadata or logs of what they say they're looking for, there's going to be yet another accusation. And I do not want to invite needless accusations when it's beyond our duty. Our duty is to provide the videos. What more can we do than to invite the defense themselves to come into the Canton Police Department and take a look at the system? So if there's something they want, then we'll copy it.
Okay. Thank you very much. All right, Ms. Giannetti, the next one should be fairly quick and simple. The motion for Pro Hac Vici. I asked you before when Mr. Alessi joined us, you have a rather vague good cause exists to grant this motion because Mr. Betterow, is that how you pronounce his name?
Yes.
Betterow has specialized skill and knowledge in representing defendants in matters of this nature. I asked you last time what you mean by that.
Right.
I need another affidavit. As soon as I get another affidavit that has a little bit more in it, I'll likely allow the motion.
Understood. And would the court require further oral argument, or do you anticipate potentially allowing it on the papers, Judge?
I would probably allow it on the papers unless I know there's an opposition, but
Okay. Thank you.
it's rare. All right, but I need a more detailed affidavit.
Your Honor, may I have just a moment with counsel? Thank you, Your Honor.
Okay, the next one's paper.
May I be heard briefly?
Yes,
May I be heard briefly?
yes. So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay,
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing long-term implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to Special Attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow, who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried, about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each. And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case. It doesn't. And that concerns the government. And so while I do not object to Attorney Betterow, they should have as many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case, and whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen. And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse, and that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial, and the witnesses are entitled to walk in this courtroom without being abused. Thank you.
Okay. Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right, we'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one I believe is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of Gretchen Voss and/or Metro Corp. Relatively straightforward, but I'll hear you, Mr. Burnham.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach. So I'm asking permission for me to be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay, there's no objection to this, is there?
No, Your Honor.
Of course, I'll provide
Yes. All right, so this is allowed. All right, so the next is paper 490, defendants rule 14 and 17, motion for court order authorizing defense access to the Lexus and Traverse and to the driveway at 1 Meadows Avenue in Canton to conduct an independent testing and analysis. I did receive this morning an affidavit from attorney Mark Diller on behalf of the O'Keefe family in response to defendants rule 14 and 17 motion for court order authorizing defense access to the Lexus and Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. I assume counsel has seen this affidavit of Mr. Diller?
Yes, Your Honor. In the interest of saving time, I would alert the court that Mr. Brennan and I have conferred prior to today. And today he handed me a drive that appears to have the 3D scans that we were seeking.
Okay.
So that may well satisfy us. And I would ask that the court take no action on this motion until we've had a chance to view them. And we may not need to have action on this motion.
Okay. I do just want to say it's clear from this affidavit that there's the spirit of cooperation, even though unnecessary, frankly, on behalf of the O'Keefe family. So I would not do anything really other than what their lawyer has suggested.
Understood.
Okay. All right, so no action taken. So the next is paper 493, defendant's motion to reconsider reciprocal discovery order, and paper 503, the Commonwealth's opposition. So who is arguing this motion for the defendant?
I will be, Your Honor.
Okay, I'll hear you.
Would you like me to address both issues first or?
Both issues.
Okay. So, Your Honor, taking first the motion to reconsider the reciprocal discovery order, I start by acknowledging that the court has wide discretion in this area with regard to discovery orders and reciprocal discovery orders. I'm also aware of the court's ruling in the first trial whereby we were ordered essentially to turn over any evidence that we were going to use when impeaching Commonwealth's witnesses. And that's what we're asking the court to reconsider. It is our position, Judge, that, part of, and I believe I quoted a case on the last page of the motion, the effectiveness of page 12, Judge, of my motion. The effectiveness of cross-examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. And with regard to at least two witnesses, the examples that we outline in the motion, we were deprived of that very legitimate exercise of confronting a witness and surprising them with an inconsistency in their testimony. With regard to, Ms. McCabe, it was never mentioned anywhere that she spent an hour at the personal home of Mr. Lank from the Canton Police Department. That only came up after we were ordered and did produce, pursuant to the court's order, the geofence data, which revealed that meeting did take place. And so, the Commonwealth, armed with that information, went and talked to her about it, obviously, because she was very well prepared on cross-examination to address that issue and came up with a very detailed explanation that appeared to diffuse the fact that she hadn't mentioned it before. She was very well prepared for that. And secondly, with regard to the juvenile witness. As the court remembers, I'm sure from the first trial, we had that video of the steak tips incident, and it clearly did not show the type of animosity that had been originally prepared. And so when it came time for trial testimony, it turned into something different. It turned into, well, that was a takeout incident, which, you know, we question what was done behind the scenes to, you know, arrive at that conclusion as well. And, you know, I also, you know, include in the motion, and just to be clear, Judge, this is something I will start with in addressing the motion for sanctions. This is my motion. I drafted it. None of my co-counsel saw this motion before it was filed. So I take responsibility for everything that's in there. But, you know, we also make the point that with regard to, you know, Trooper Proctor, it appears as though there was, you know, he was monitoring the trial. At least that's the inference that we draw, because he specifically says the one part that he didn't want to watch was Mr. Jackson's closing argument. And he obviously uses derogatory language toward him as well. You know, if we turn over this information in advance, not only does the Commonwealth get a chance to blunt this information by having the witness be given an opportunity to mold their testimony to take into account the impeachment information, but, you know, this is a, I won't say unique trial, but it's a rare trial that, you know, is streamed online. There's obviously a lot of press interest. Some people are watching everything that goes on. The court has issued sequestration orders. We don't know for sure whether they've been complied with. And to the extent that we turn over this impeachment material and the Commonwealth uses it, you know, it's another opportunity for a witness to see potentially in advance something that could otherwise be damaging toward cross-examination. So switching to the Commonwealth's motion for sanctions.
You know what, let's wait. When I said both, I thought maybe 2 points that made up to.
Understood, understood.
All right, so, Mr. Brennan?
The court shouldn't force reciprocal discovery. You shouldn't force it, Your Honor. Trial by ambush is simply that, trial by ambush. There were many instances when I reviewed this trial where the defense came up to sidebar, they had pictures, photos, things they didn't turn over that they expected to use for impeachment. And the rule requires them to do that. The reporter's note to Rule 14 talks about reciprocal discovery. Quote, even-handed discovery to both sides will improve both the administration and the delivery of justice. A witness has a right to look at information before their testimony. Just like the Commonwealth provides all evidence to the defense should do the same. Now, it's notable in the rules, although they're changing March 1st. We look at Rule 14A1A. That has a limitation in discovery for the Commonwealth under the person's direction and control. The reason for that is because the Commonwealth, unlike the defense, must provide all discovery in their possession and control. So, for example, if the Commonwealth is going to call an expert, they have to provide everything. Although the rules are a little bit more limited, it is the best practice to provide everything. If the Commonwealth is not going to call a witness, they still have obligations. And that is why that language is in Rule 14A1A. If the Commonwealth seeks consult with somebody, they're not going to call, they need to produce it to the defense. For example, I get random emails from unknown people, anonymous, or sometimes there are names on them, talking about theories of the case. I give it to the defense. Because it's in my possession, custody, or control. I have no intention of calling an anonymous person, but because I have the information, because I am the Commonwealth, they're entitled to it. If we look under 14B, it's different for the defense. If they're going to call a witness, they have an obligation to produce evidence. If they have evidence they're going to use at trial, they have an obligation to provide it. And so allowing the defense to simply hide information because they think it's impeachment at trial is uneven-handed. It's not fair play. It's not in the interest of justice. There is no caveat or exception for the defense that they're entitled, in state court anyways, federal rules are very different, in state court for them to withhold reciprocal discovery. The order of the court at the first trial, even though it wasn't followed religiously, was that reciprocal discovery was an obligation of both sides. And that should not change. It's going to create chaos. It's going to create delay in the case, and it's going to create an unfairness. It will be trial by ambush. It will be. And so since there is no caveat or exception for the defense, and since there's no entitlement to withhold impeachment material, we should not make an exception for this team. They should provide it like everybody else. So I'm asking you to maintain the reciprocal discovery order that is already in place, and then hopefully at this trial, it'll be abided by.
Okay. Was there any follow-up to that? The motion for sanctions will be a little bit later.
Right. No, the only thing I would point out, Your Honor, is that with regard to the report of Jen McCabe, or Jennifer McCabe, I should say, revealing this length meeting, that report wasn't provided to us until after she testified. And I think this court remembers from the trial that there was sort of a rolling discovery that we received even as the trial was going on. So I just wanted to make that point.
Okay.
Your Honor, I've tried my best, and I will continue to provide all discovery timely to the defense.
Thank you.
I've been on the side where late discovery comes in a trial, and I never want that to happen. Sometimes exceptions happen on both sides, but that is not the intent of the Commonwealth. The Commonwealth is doing everything possible to give the defense more discovery than they're entitled to as early as we can.
All right. Thank you. Next is paper 495. This is defendant's motion to compel discovery, and then there was a response from the Commonwealth. Paper 502. So who's arguing this for the defendant?
Thank you, Your Honor.
Okay.
Your Honor, we filed a motion to compel certain discovery that is still outstanding. There's 10 items. I'll address those in turn. The first request deals with...
So you have the Commonwealth's response, right?
Yes.
Where it doesn't object to some. Are you going to skip over those? Or
Yes, of course,
okay.
Your Honor. For those, I'll just ask that the court allow those requests. For request 1, Your Honor, we've asked for all chain of custody logs, reports, evidence logs, and other documentation regarding how the Norfolk County District Attorney's Office and the Massachusetts State Police came into possession of each distinct production of Canton Police Department video surveillance footage from January 29th. As the court has heard many times, we have received 3 separate productions. One before trial, which was missing the precise time Ms. Reed's Lexus was brought into the Canton Sallyport garage. Another production in the middle of trial, which included an inverted video showing only the left portion of Ms. Reed's taillight, not the condition of the right rear taillight in the Sallyport garage when it was first brought in. Then we have a third production, which was not turned over until after trial in this matter. In that production, we have video surveillance footage from outside the Canton Police Department, where it shows Brian Higgins on his cell phone talking to someone at 1:30 a.m. outside of the Canton Police Department. The only report or documentation associated with any of those 3 productions is a singular report from July of 2024 that details an IT person, Colleen Crawford's, review of video surveillance footage and summarizing information about what she looked at. We have no chain of custody logs, no evidence logs, no reports regarding the download of that information. We don't know who the custodian of records is with regards to those 3 productions, or how this information magically appeared in the Massachusetts State Police and Norfolk County DA's possession. We are entitled to that. We're simply asking for what we have in all the other video surveillance footage, evidence logs, a copy of when that was booked into evidence. The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts State Police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when. And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos. But that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There's certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper Garino. Lieutenant Brian Tully. Trooper Kathleen Prince. And Norfolk County District Attorney Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer. It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically, in terms of our requests, we've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that really there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder. The text messages, which are publicly available, and referenced in federal search warrants affidavits are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Guarino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects. As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that information.
So if it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
Okay.
Thank you.
All right. Mr. Brennan.
It's important to represent facts accurately. And the court has ordered in the past, when representations have been made, that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to then now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady v. Maryland in Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the State Police General Headquarters in possession of any relevant materials, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this matter. The Commonwealth is under a continuing duty to inquire and obtain all relevant evidence pertaining to witnesses in the matter of Commonwealth v. Karen Reed. All potentially exculpatory and relevant evidence must be disclosed to the defense. Exculpatory evidence is any evidence that would tend to exculpate the defendant or tend to diminish credibility. Exculpatory evidence also includes any allegations of misconduct that bear upon the truthfulness and the integrity of the investigation or could be read as suggesting bias or would question one's credibility to be impartial. In addition to any obligations under Mass Rule 14, Commonwealth alerts Internal Affairs Division of Massachusetts State Police to an ongoing Mass Rule Criminal Procedure 17 order for the production of records regarding the investigation of Trooper Michael Proctor, to the extent that any records beyond that was initially produced in March 19, 2024, please provide forthwith to the Commonwealth and the defense. So we are and have made best efforts to provide all of that material. The defense is entitled to it. We cannot force them or compel them, but there is the Rule 17 motion, and we'll continue to abide by our obligation and duty. Number 6 and 7, we do not object. Number 8, there is a difference between ARCA, and we'll discuss that in more detail when we get to the ARCA motion, and expert discovery. We have provided, there is a difference between ARCA as an expert witness and typical expert witnesses. I can assure the court that we provided our entire case file for our accident reconstruction expert. We provided all of our materials for all of our experts. The discussion between the experts, the oral discussion between the experts and me cannot be replicated. If there was anything inconsistent or exculpatory or helpful for the defense, I would reduce it to writing and I would provide it to them. They have all the materials our experts relied upon. They have all of the reports. They have all the raw data. They have the research material. I do not believe that tracking phone calls for a regular expert is possible, number one, and has any relevance whatsoever. It is different for ARCA, and again, I'll delve into that when we talk about ARCA because that is a very unique situation. We have been very broad in our expert disclosures. Written communications, number 9, email, text message between Norfolk County DA's office, law enforcement, and any expert. Again, there's scheduling issues. I've been through emails and text messages, and I have given a healthy production of materials that are relevant, would even suggest any type of bias. And in addition, I've asked for a production of any statements whatsoever with any witnesses in this case so that I can review them. And I've received production from 2 troopers in this case that I have to review. I received them at the end of last week, and I'll continually look through all correspondence available to me for Rule 14 materials and provide it.
All right. Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right. So I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number yet for the motion.
Yeah, we'll have to find, I mean, we're
can
over
look that up.
500 at this point, so.
Yes.
All right. All right, so next we'll move on to the so-called ARCA motion, Commonwealth's motion to exclude employees of ARCA, paper 497, and the opposition 505. So, Mr. Brennan? Sure.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA, or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh, don't tell them. Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
Court, all rise, please.
Is that it? Is that the end? Are we on a break? I was a little bit behind. Leaving on a yep, that's leaving on a mic drop. Brennan. Okay, thank you, Lou. It's just a recess. Thank you. I thought so. That was a mic drop. So these ARCA experts that we were hearing about, this is really the free Karen Reed argument. But the ARCA expert says he couldn't be hit by a car. No. First of all, they were asked a very specific question. Could his head injuries, John O'Keefe's head injuries, be caused by being hit by a car? Very different. And they admitted on the stand that they could not rule out John O'Keefe being hit by or clipped by a car. So I think, we're talking about two different things, being hit head on and being clipped. And we were told these were independent FBI of course they're testifying for the defense. They could have testified for the prosecution. That's what the free Karen readers would say. But here, Hank Brennan comes with a whole bunch of communication between the defense and ARCA. Showing that they were very biased towards the defense in this case. Why, I don't know. I mean, you could see it on the stand, or I could, that they were biased in the way they were answering the questions. They had been, just like Hank Brennan said, he'd been around the court system. Here, yeah, I agree. Jennifer Ray makes the best point here. Thanks, Jennifer. Judge Bev needs to start getting tough on the defense. I don't know if she ever will. She seems to be a very pro-defense judge. And her ruling on Marie Russell and Richard Green were the pits. I mean, she's making her court a kangaroo court. I mean, they're just not qualified to be experts. Marie Russell, slightly more than Green. You can't have, it's not that I'm saying that Green is, he was wrong. They had to change the whole program. You can't testify to something that's been proved wrong. I mean, scientifically just wrong. That's not an opinion. It's just wrong. I mean, it's akin to having a flat earther up there saying, the earth is flat. It's not, sure, it's an opinion, but it's a scientifically wrong one. By all the evidence that we have that he's wrong. So, are we going to start, the reason you rule out experts like that is so that you're not making the Commonwealth argue and the defense argue over basic facts, scientific facts. This is not the case of the Commonwealth versus, oh, now I've forgotten the name of the Cellbrite. I just forgot it for a second. Forgive me, guys. I haven't made any coffee yet. So, this is the case of the Commonwealth versus Karen Reed. So now Judge Bev has made a situation where they have to convince a jury, and have a jury argue over things that or just should be unnecessary to argue over in the jury room and confuse a jury, one juror or two, or right, run the risk of confusing a juror. And I guess I'll talk about my juror. I really learned so much from being a juror on a criminal trial last year. It wasn't my intention. My intention was to get kicked out in 15 seconds. I assumed doing this would get me kicked out, but it didn't. Was that we had one juror, so our first vote was 11-1, and one juror thought she had heard this and that. It was totally testimony that was never said, or so. I mean, you can have these jurors that just, I don't know what they're doing. I don't know what that juror was doing. I don't know what she was listening to. Not the same testimony that the 11 of us all listened to. So that is what's going on. Wow. This has been a really excellent, exciting hearing. This is not entertainment. The law can be tedious, we've seen, certainly. But that was certainly unexpected. Did anybody expect that in the audience? I didn't. I'm not surprised with the way Karen Reed's defense is. They're fraudster lawyers. Run fast and loose with the rules, the laws. It's something. It really came perfectly with the break. Yeah, Big Van says no. Right, I didn't expect it either. I didn't expect that. We knew they didn't want to hand over stuff. When they did, it's like, woohoo. I have my cat snoring next to me. Can you hear him? Oh, maybe not now. Maybe he stopped. Maybe he woke up for a second. Oh, there he is again. All right. Wow, that was good. I almost want to go back and watch it again, but I don't want to miss anything coming up. How long is this break? Should we watch some of that again? Is it 5 minutes or 10 minutes? Does anyone know? It will be a while? Okay. All right. I'm going to try not to miss. Let's just watch that again. That was something. I'm going to try to keep my eye on the
It's not
on the Core TV feed on my phone.
enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, And it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before the response.
Court, all rise, please.
Damn. Holy cow. So what they're saying is, and this is what I think happened with all the witnesses in this case. Okay, and I'll explain why in a second. So what they're saying is, or Hank Brennan's saying is, ARCA said, if you don't want me to say anything about most pedestrians being hit at night, because John O'Keefe was hit at night. So, that's not really helpful. Most of these accidents happen at nighttime. Let me know. So ARCA is basically creating their testimony with the defense and it also sounds like the feds. So right, exactly, twisted tragedies. They're not independent. They're not unbiased. And then they go on the stand and say, we're unbiased. We don't care which side wins. We knew they weren't. But so I also think this has happened with Dr. Russell and Hank Green. There's no reason why Richard Green. I'm having a morning, guys. I'm having a morning. Richard Green, because first of all, as when Alessi got involved, their language changed in their reports, and their experience also became much richer and deeper. You could say, well, maybe Marie Russell didn't know that she could mention blah, blah, and blah, blah, blah. But I'm certain that all the defense witnesses did this kind of stuff with the defense. There's just no reason for Richard Green to hang on to his opinion, his 227 opinion, except that he knows he won't get paid if he doesn't hang on to it. They've already rewritten the computer program. That was ridiculous. Terrible ruling by Cannoni on that. Sorry, I can't get over how bad a ruling. Never seen such a bad judge's ruling. And Marie Russell is second place for terrible rulings. Maybe we're going to go for, maybe they'll be trumped by this. Maybe this will take first place if ARCA can be allowed in and that they can continue to hide their discovery. What's going on with Massachusetts courts? You know, that happens. So I think Hank Brennan made a great point at the end. He's like, I'm happy to have them testify. Just let me know what the situation is. He will destroy them on the stand with just the discovery that he has. So just imagine this. And this is something that I talked about with John Lewin, prosecutor John Lewin, when I was making some of my no content. He said he starts out with these experts. Oh, so are you an unbiased, impartial witness? Yes, I am. Oh, really? You know, here's Exhibit A. You know, most pedestrian, here's a communication from you to the defense. Al, do you want me or the feds? Most pedestrian accidents occur at night. Do you want me not to say that? Or put up his communication with Alan Jackson. I thought your voir dire was excellent. If you don't want me to say anything, let me know here, or, blah, blah, blah. Do you want me to change this or that? I mean, that we already heard from that juror. I don't know what to think of that juror. I'm suspicious, but what it sounds like, it's so strange that they didn't really accept any of the defense witnesses, and yet still, and that's entirely due to the innocence fraud campaign, in my opinion, they hung. They didn't think any of them were credible. And I said it. I mean, I made an episode called Garbage Defense Witnesses. Everyone said, you didn't know, all the free Karen readers say, you don't know what you're talking about. I do know what I'm talking about. They were garbage witnesses. They look like bottom of the barrel. Lucky Loughran, bottom of the barrel. ARCA is the only one, the best thing they had up their sleeve. And they may have more witnesses here, but if Hank Brennan's smart, he's going to get to every communication with every witness and make sure it's handed over. Because, you would be a fool to think that this is the only time they've done this with their witnesses. And you could just see Alan Jackson's face. I mean, just getting a beating. He had to know this beating was coming in court. Maybe that's the point of the latest Karen Reed interview. Throw that out before this hearing. Because they're taking a beating in court. And I wouldn't be surprised if a few of the free Karen readers, not any of the major ones, but a few, might walk away after this. Because they really have been hanging on ARCA being non-biased witnesses, right? That's what I have to say. What do you guys have to say about it? They thought she would be acquitted. I think they thought, I thought they thought they would never get to trial. That was the whole point of all the hearings last trial. Hank Brennan's no fool. He knows the sleazy defense tricks. Yeah, Green seems just desperate for money, you know? I mean, anybody, McNasty Green, McNasty, Richard McNasty, or McNasty Green. Marie Russell needs a nickname, doesn't she? Attention seeking. Marie Russell. It's usually what I call her. She desperately needs to be seen as important. When she testified that she was more qualified than any person in the United States or whatever to deal with dog bites, I had to laugh. She has delusions of grandeur for sure. That's a phrase that applies to her. Or maybe what is it? Dunning-Kruger effect. Marie Jack Russell. That's funny, Barb. Yeah, I agree. You should put his mugshot up on the screen. I mean, that guy. I mean, you just wouldn't. I don't think I would want Richard Green to fix my computer. I don't want him anywhere near my computer, let alone analyze data in a murder trial. So, I mean, maybe they'll get a new expert, a new biased expert to say that looks like that. I was curious to see that the O'Keefe family is going to say that they can go to the driveway and see if Karen Reed could do that damage. You know, they have a defense witness ready to say, oh, that damage could be done by that love tap. You can smash your car taillight to smithereens with a love tap. Okay, here we go. We're back. I'm going to pull myself out and make the picture bigger.
Back to session, may be seated, make sure your cell phones are off and put away.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
It would have to be at 9 o'clock in the morning.
Here, if I may hand up the discovery that was
Thank you.
provided by the defendant referenced by.
Oh, great, thank you.
Is there any way we should be suspended for today?
We can do the afternoon of the 25th if the morning doesn't work.
The problem I have, Your Honor, is I've got a hearing on the 24th. I have to fly on the 24th even to be here.
So you can be on Zoom for this if you want, Mr. Jackson.
I'd rather be here, but I have to accommodate whatever the court's calendar is. I have to accommodate the court's scheduling. If we could do it live, I'd rather do it live, but I will accommodate the court's calendar.
Are all parties available at 9 on the 26th?
I'm not.
May I have just a moment?
Yes. Thank you.
Your Honor, we'll accommodate the 25th, one way or the other.
All right. So we'll see everyone.
Your Honor, I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
All right, 11 o'clock on the 25th.
Thank you.
All rise to the court, please.
I've never seen anything like that. I've seen judges get really angry at, and they shut off the camera really quickly too in the courtroom. I'd love to see what's going on in the courtroom. I've seen judges get really angry with the defense in the Nexium case, but not over something like that. Not over something. This is really serious. And this is what I've been saying all along, is that we have lawyers and Judge Cannoni's been letting them just go practice beyond the bounds of their profession, the rules of their profession. You can't do that. You can't present to the jury this unbiased expert and have these kind of communications. where they're modifying their testimony to please the defense and big upping the defense. Great voir dire. You don't want me to say this, I won't. I almost want to watch it one more time. Does anybody want to watch it one more time? Or have I gotten too, I think it's just crazy. No, I mean, yeah, I mean, that was something. Yeah, you want to watch it one more time? Okay. We have some obsessives like me in the audience. All right, hold on. Let me pull it up. I think I just closed the window, but let me just pull it up again. Hold on. "16 hours ago, 1 minute ago." That's what we're looking for. Okay, here we go. Let me just get to the part. I'll be with you in 1 minute. Yeah, okay. So we had a long break. Yeah, it was, I mean, it's like a TV movie or something. And we had no sense of what was coming either, did we? You know, we were all ready for what Alessi to kind of bore us with his motion. Can Alessi do his motion? No. No. No, he can't. Sorry, Alessi, you're out of luck. You're in big trouble. Alan Jackson's like, "I'd like to be here for it." Yeah, I'm sure you would, because you're going to get. Also, I mean, it's not just that he's probably like to see Karen, but he also, you know, he's really, you know, he was the one mentioned in that email. Alan, you know, blah, 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 blah. So let's watch it one more time. And then I'm going to get on with my day, and I'll see you guys at 6. But let's watch it one more time.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented, these experts were hired by the federal government and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter. in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA or not. I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them. Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for 23.
Is my computer freezing? Hold on one second. Let me. Guys, hold on one sec. Okay, I'm back. Sorry, guys. My computer just absolutely froze up. I don't know if that was my internet or what, but I'm back. All right. Let's continue with this delicious. My girlfriend brought up a really good point. He's not just calling out the defense here, he's calling out the judge, because when they say we have no contact, remember they said the same thing about Marie Russell last trial? We had no contact with her. They'd have to do these voir dires instead. And I think that's what he's referring to. Did ARCA get voir dired? I can't remember last time, because they would never hand over this discovery. Does everybody remember that? And Judge Cannoni bought this. I mean, that was her That was her solution. Oh, we'll just have a voir dire of the expert witness. Yeah, they did. Thanks, Brittany. They did. Same thing. So they made a fool. So it's Hank Brennan's not just making a fool of the defense. They could get sanctioned for this. And they're asking for sanctions for releasing Michael Proctor's text message to the public. The the Commonwealth is asking for the defense to be sanctioned over that. They made a fool out of the judge. That's her ego, they're in hot water.
Marca to the defense for $23,925. That's not Trimble. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. Sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome Marca.
All right, I'm going to take a recess before the response.
Court, all rise, please.
Yeah, my apologies about my loud noise from my heater. I can hear it coming through my headphones. So that's it. I'll talk about this tonight at 6. It's going to be a good one. But yeah, curious to see how the Free Karen readers are taking this. But, add this to the list of times the defense has overstepped the bounds of the law, overstepped the bounds of their profession, and they need to be brought up, I think, for their bar. These issues, because they will continue to bamboozle the courts with this same kind of technique. All right. Have a great day, everybody. I'll see you guys at 6.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, gin, like John, you were my mark. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, gin, like John, you were my mark. since fraud campaign is my biggest hit yet.